Um, Welcome back to the Deep Dives. Today, we are heading into the shadows.
Oh, definitely into the shadows on this one.
Yeah. I want you to picture Puerto Rico at the turn of the millennium. It is humid, it's tense, and the lines between the good guys and the bad guys aren't just blurred, they are practically erased.
Right, the whole system was compromised.
Exactly. We're looking at a massive corruption scandal that shook the island's police force to its core. But inside this sprawling true crime story is a very specific, a very sharp legal puzzle that could trap anyone who thinks they're being clever with the police.
It's a puzzle about the extreme danger of the half-truth.
Yes. Imagine you witness a crime. Actually, let's raise the stakes for you. You are a police officer. You know your colleagues are dirty. You know they are moving drugs.
And terrible spot to be in.
Right. So your conscience pricks you, and you call the feds. You say, something is going down. But, and here's the twist, you stop right there.
You hold back.
You don't give names. You don't identify yourself. You give them a slice of the truth, but you hold back the rest. So the question we are exploring today is this. Can you be convicted of concealing a crime if you actually called the authorities to report it?
That brings us straight into the doctrine of misprision of felony, and the answer depends entirely on whether the law views your partial truth as a helping hand or a deliberate cover-up.
Our protagonist in this noir thriller is Osvaldo Caraballo-Rodriguez. He was a cop caught in a sting operation codenamed Honor Perdido, which translates to lost honor. Great name, by the way.
It really is.
So our mission today is to dissect his case, United States v. Caraballo-Rodriguez, and figure out if telling a partial truth is legally the exact same thing as lying.
I am ready. This case is a goldmine because it forces us to walk a very fine line between inaction, which is usually legal, and concealment, which is a felony. To really understand this, we need to be precise. We are going to break this down into 4 parts. First, we need to define misprision of felony under federal law. Second, we have to look at the Ciambrone scenario to see how other courts handle partial truths.
Okay.
Third, we will do a rigorous element-by-element analysis of the Caraballo case. And finally, I will give you a diagnostic checklist to spot this issue in the wild.
I do love a checklist. But let's start with the basics. We hear misprision of felony, and it sounds like, I don't know, something from a medieval dungeon. What does the statute actually say? What is the foundational definition?
It does sound archaic. I mean, it goes way back, but it is very active in the federal code under 18 U.S.C. Section 4. The general rule is fairly straightforward on paper, but complex in practice.
How so?
Well, to prove misprision of felony, the government must prove 4 distinct elements. If they miss even one, the defendant walks.
Lay them out for us.
Element 1, the principal committed a felony, so someone else did a bad thing. Element 2, the defendant had actual knowledge of that crime. Element 3, the defendant failed to notify the authorities. And element 4, this is the one we're going to obsess over today, the defendant committed an affirmative act of concealment.
Okay, let's pause on that 4th one. An affirmative act. That sounds like you have to physically do something to hide the crime. Why is this specific element so controversial?
Because it creates a massive distinction between modern federal law and the Old English common law. Back in the day, under common law, if you knew about a felony and just sat on your hands, you were guilty. You had a strict duty to report.
Right, you had to say something.
But under the federal statute, mere silence is generally not a crime. You can watch a crime happen, know exactly who did it, say absolutely nothing to the police, and you typically cannot be charged with misprision. You have to take an active step to conceal it.
That is wild. So silence is a shield. If I say nothing, I am safe. But if I try to be a little bit helpful, I might actually be in trouble.
That is exactly the tension. Silence is safe. Partial speech is risky.
Before we get to Caraballo, I need to visualize this. You mentioned the Ciambrone scenario earlier. Can you give us a hypothetical that shows exactly where the line is drawn between silence and this partial disclosure trap?
Sure. This comes from a Ninth Circuit case involving counterfeiting. Imagine a man, let's call him the snitch, knows about a massive counterfeiting ring. He knows the names, he knows the location of the printing presses, he knows it all.
Okay, a gold mine of information.
Right, so he walks up to a Secret Service agent and says, I know about a counterfeiting operation.
So he is opening the door.
He is. But then he stops. He refuses to give names. He refuses to give the address. He just drops this nugget of information and then zips his lips. The government charged him with misprision, arguing that by holding back the details, he was actively concealing the crime.
That feels intuitive, though. He is hiding the most important parts.
Yeah.
So is he a criminal or a helper?
In the Ciambrone case, the court said he was not guilty of misprision. Their logic was fascinating. They said that because mere silence isn't a crime, giving partial information shouldn't be a crime either, as long as it doesn't actively mislead the
Oh,
police.
wow.
The court basically said, look, the government is no worse off with a partial tip than they would be with total silence.
So on the West Coast, in the Ninth Circuit, you can tease the police with half the story and walk away clean. Now let's travel to Puerto Rico to the First Circuit and see if that logic saved Osvaldo Caraballo-Rodriguez. Let's analyze United States v. Caraballo-Rodriguez. First, what are the legally dispositive facts?
The year is 2000. The FBI and DEA are running Operation Honor Perdido. They are targeting corrupt cops who are protecting drug shipments. Caraballo is one of these officers. The timeline here is critical, so follow closely. On May 24, Caraballo makes an anonymous phone call to the DEA.
This is his snitch moment.
Yes. He tells the DEA, I know about police involvement in drug trafficking. He specifically mentions that a female officer approached him to join the scheme. But, and here is the kicker, he refuses to give his name, and he refuses to name the corrupt officers.
Okay, so just like the counterfeiting guy. He drops a truth bomb, but keeps the details. What happens next?
That was May 24. On May 25th, the very next day, Caraballo shows up and actively participates in transporting 10 kilograms of cocaine.
Wait, hold on. He calls the DEA on Tuesday to report the ring, and on Wednesday he is driving the drug car. What was he thinking?
It is baffling behavior, but it shows how conflicted he was. Now, the cocaine was actually fake. It was a sting, but his intent was real. 2 weeks later, on June 8th, he meets with DEA agents again. This time, the jig is up. He confesses, he names the co-conspirators, and he admits he took $4,000 for the job.
But I assume the confession came too late to save him from the cover-up charge.
Correct. He was indicted for misprision of felony. He initially pled guilty, but then, realizing that maybe what he did wasn't technically concealment based on cases like Ciambrone, he tried to withdraw his guilty plea. He wanted to fight the charge.
And what was the core legal issue?
The issue is two-layered. First, a substantive criminal law issue. Did Caraballo's anonymous tip, which was truthful but partial, constitute an affirmative act of concealment? And second, a procedural issue. Did the trial court commit plain error by accepting his guilty plea in the first place based on those facts?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
Because Caraballo had already pled guilty, he had a mountain to climb. The court applied the plain error standard combined with the substantive law of misprision of felony.
Break down the plain error rule for us.
The plain error standard has 4 strict elements. First, there must be an error. Second, the error must be plain, meaning clear or obvious under current law. Third, it must affect substantial rights. And fourth, it must implicate the fairness or integrity of judicial proceedings.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the affirmative act of concealment?
This is the heart of the argument. Caraballo argued that his anonymous call was exactly like the Ciambrone case. It was a partial truth that provided some help. He argued that because he told the truth about the female officer, he wasn't concealing anything. He was just failing to disclose everything.
Right, and failure to disclose isn't a crime.
Exactly. But the First Circuit rejected that logic. They reasoned that a truthful but partial disclosure can actually be more dangerous than silence. They argued that partial truths can be misleading. They might lead the police down a false trail or make them think they have the whole story when they don't.
So any action changes the math.
Yes. The court held that while silence is passive, making a call is an active affirmative act. If that act diverts the investigation or shields the conspirators by omission, it meets the element of concealment. The court found Caraballo didn't prove his tip wasn't misleading.
Understood. Now, what about the second element, the plain error requirement that the mistake be obvious?
This is where the hammer dropped on his procedural hopes. For an error to be plain, the law must be settled, it must be indisputable. The First Circuit looked at this and said, we have never officially adopted the Ninth Circuit's Ciambrone rule here.
I see.
And frankly, no other circuit had uniformly adopted it for partial disclosures either. Because the law regarding partial tips was unsettled, the trial judge did not make an obvious or plain error by accepting his guilty plea. The element was not met.
And after analyzing all the elements, what was the court's final conclusion?
The conviction was affirmed. Caraballo was not allowed to withdraw his plea. The court synthesized the analysis by holding that a misleading partial tip can be an affirmative act of concealment. And because the law wasn't settled in Caraballo's favor, accepting his plea was not a plain error.
But it wasn't a unanimous decision, was it? There was a dissent that really strikes a chord.
Yes, Judge Torella dissented. And his argument appeals strongly to common sense. He basically asked, why are we punishing someone for helping a little bit? He argued that Sam Brown was right. Partial information is inherently better than no information.
It seems obvious when you put it that way.
Right. By punishing Caraballo, the court is essentially telling people that unless you are going to spill your guts completely, do not call us at all.
That is the policy nightmare. It seems like the majority ruling incentivizes total silence. If Caraballo had just driven the drug car and never made that phone call on May 24, he wouldn't be charged with misprision. He would be charged with the drugs, sure, but the cover-up charge only stuck because he tried to speak.
Precisely. It creates a deeply perverse incentive.
We have covered a lot of ground. We've got the sting, the conflicting circuit court rulings, and the intense procedural hurdles. For the learner listening to this, maybe a law student or just someone who wants to be smarter than their lawyer, let's synthesize this. Can you give us a diagnostic checklist for issue spotting misdriven to felony?
I absolutely can. If you are looking at a fact pattern where someone knows about a crime, here is your 4-step exam framework. Step 1, check for duty.
Okay, duty.
Ask if there is a special duty to report. Caraballo was a cop, which clouds the moral issue, but generally under federal law there is no duty to report unless you take an active step to conceal. Step 2, the mere silence test.
Did they keep their mouths shut?
Exactly. Did the person just stay quiet? If they sat there and did nothing, that is likely not misapprehension. Silence is your shield. Step 3, the partial disclosure trap. This is the danger zone. Did they say something but hold back?
Right, the snitch scenario.
If yes, ask the diagnostic question. Did this partial info mislead the authorities? And crucially, check your jurisdiction. If you are in the Ninth Circuit, you have the Sam Brown defense. If you are in the First Circuit, you are in Caraballo territory, and you are at serious risk.
Location is everything.
It really is. And finally, step 4, the affirmative act. Look for the specific behavior. Did they give a fake name? Did they destroy evidence? Or, as we learned today, did they give a tip that sent the cops chasing a ghost? You need that active verb to make the charge stick.
That step 3 is a killer. Check your jurisdiction. Justice literally changes depending on which map coordinates you are standing on.
That is the reality of the Federal Circuit split system.
So let's wrap this up. The real revelation here isn't just about corrupt cops in Puerto Rico. It is about the legal nature of truth. We grow up thinking that telling the truth is a binary thing. You either do it or you don't. But Caraballo teaches us that the law sees truth as a spectrum.
And if you stop halfway along that spectrum, the law might actually treat you worse than if you never started.
I want to leave you with one final thought, building on Judge Toruella's dissent. If the ultimate goal of the justice system is to solve crimes and uncover the truth, why do we tolerate a rule that terrifies the hesitant witness? If Caraballo had known his anonymous tip would be the very thing used to lock him up for a cover-up, that phone never would have rung.
A chilling effect.
Exactly. And maybe the government would have remained entirely in the dark, knowing even less than the half-truth they got. It forces you to ask, do we want a justice system that demands absolute perfection from the start, or one that accepts messy progress, something to mull over the next time you have a secret to keep? That is it for this deep dive into the legal jungle of Caraballo-Rodriguez.
Watch your words and watch your silence.
We will see you on the next one.